I'm going to give you that.
Well, anything addressed to me as an individual, actually, you can't serve a notice to me. You can serve something to the bank, but I understand you feel that you can implicate me individually.
You are not a representative of HSBC Bank PLC.
Yes, I am.
Okay, this is to you as a representative of HSBC Bank PLC.
From what you've said to my colleagues, is you feel that you can implicate me personally.
Well, you are, because you are a trustee. Yeah. You are responsible for the monies. You've made several false claims in your letter.
You are welcome to make that deposit, and that will be dealt with. But any response from me will come in form of writing, and it will be a summary of findings from our legal team.
Can we ask? You said in your letter.
You can ask questions, but I'm not going to disclose any information to you verbally. Any information will go in writing to you.
So what we're asking you to do is to respond to this notice that we're giving you today and answer all the questions within.
Okay, that's fine.
Okay, that's the notice. It's got a list of questions in there.
Okay, you can put that onto the table.
I'll hand it to you.
Well, that's all right. That's all right. We consider that served. That's been given to the record, and I am recording this.
Okay. You're aware that you are supposed to ask for permission?
Well, actually, I'm able. Let's just assume for 1 second that the Data Protection Act did apply as a statute to me. Okay, that would assume that I'm here as the Mister or the person, which I'm not. I'm here as the man, the human sovereign. Let's assume that was the truth. You're able to break the law in order to prevent a greater crime from taking place, and what you're committing is fraud.
Absolutely.
Because you're claiming that a promissory note is a bill of exchange, which you say that you've gone to check with your legal department. Well, we want to know the name of the solicitor that's giving you this advice, because we find that absolutely nonsensical.
So you can
and we hold you personally responsible.
Was that your advice, or was that your solicitor's advice, or the solicitor's advice?
As I said, everything will come in writing to you from
Well,
summary of findings from our solicitors.
So you guarantee that you're going to respond to our notice?
You will receive writing from HSBC.
You guarantee that you'll respond to the notice?
I don't know what is in that letter.
Are you going to read it? Are you going to read it?
You should just have to trust me.
So, okay, you're a trustee. All right, no, that's fine. We're the beneficiary of that trust. Okay. We trust you. You are the trustee. You're in there as that role.
You can leave the letter with me today, and I very kindly ask you to leave today because we all have work to do.
Not a letter. It's a notice. Yeah, you have work to do. That's fair enough. But I want to know before I go anywhere, what is the name of your regional manager?
Okay. You are obliged to give us that because, after all, you're serving the customer.
I can give you the name of the regional manager. Okay. Do you have a business card there?
Is there one in the drawer? Yeah.
Would it interest you to know that we've had a former manager of two branches of HSBC and the Queen's Bank confirm the validity of those instruments?
Okay.
Would that interest you to know that?
That's fine. I'm not making any comments to you today. I understand you're very clever with your words.
It's not clever with words.
Information from me today, which I'm not prepared to.
But just to point out, I've noticed you're smiling a lot. I suggest you stop smiling because it's no laughing matter. Okay. It's very serious.
Fine. I actually don't find it a laughing matter. I would like you to leave. You can leave your letter. That's absolutely fine, and you will receive a response.
It's not a letter. It's a notice.
Okay, that's fine.
It's a notice. It's a notice served to you as a representative of HSBC.
Okay.
We have a recording of you accepting that notice. We consider it served. Come on. Thank you for your time.
Before we go anywhere, should I not ask for, if they're not going to give my instruments back and they keep hold of them, shouldn't they be giving me face value before I leave?
Well, I mean, can we ask at least, will you give us the instrument back?
If we are to give it back to you, then you'll get it through the post, along with a letter.
Because the last time we were here twice, in fact 3 times, you made us a guarantee that the findings would be in accordance with the law. That guarantee wasn't kept to.
Okay.
Just so you're aware. Okay. You made that guarantee.
Okay. And this will be raised to the Ombudsman.
Okay.
And we will be filing an N463, which will do for a High Court judicial review.
Okay.
And what they will do is they will verify that document, just like the bank manager did. Okay, those instruments. Okay, and that's the High Court.
Okay.
All right. So there's your notice. I suggest you do read it because it is very serious. Okay. And I look forward to hearing from you.
Okay, that's fine.
Do have a lovely day.
Appearing on screen now are the documents that made up the notice and the list of questions that were given to the manager in the branch.
In these letters then, in the letter that she sent, that was dated on the 2nd of July, she's made a number of statements which are simply not true. She's quoted accurately the Bills of Exchange Act 1882 as Part 83(1), where she says a promissory note is an unconditional promise in writing made by one person to another. That's true. That's correct. That's in there. That is absolutely accurate. Then she goes on to say, the note is not payment itself, it is merely a promise to pay. In order for a promissory note to be valid, it would need to have been countersigned by the receiver. Now that's not true, because to have something countersigned by the receiver is not a promissory note, that's a bill of exchange, or cheque. And so whoever's given her this legal advice, which is why we're asking the question, who gave you this legal advice? Because they're liable. At best, they're negligent. At worst, they're grossly negligent, and therefore they're committing fraud. Now, if you read through the Bills of Exchange Act 1882, it does state on Part 89(3)(b, it says, the following provisions as to bills do not apply to notes, namely provisions relating to presentment for acceptance, and acceptance super protest. So what that's basically saying is, look, there's a distinction here between what a bill of exchange is and a promissory note. And promissory notes don't need to be accepted or signed by the acceptor. So therefore, what she's put in her letter is utter nonsense. So that's one point. She's then gone on to say about how she's referring to the admission of the fact that the telephone conversation was recorded, and for that I'll let Martin just explain why that's a load of nonsense.
Okay, so basically back to her letter, she says, I refer to your admission to the fact that you recorded our conversations both in branch and over the phone without my knowledge or consent, and would like to stress that these calls may not be shared with any outside parties or used in an attempt to take this matter further. Any attempt to do so would be in breach of data protection laws. Now that's interesting, because there's two angles on this. Firstly, how does Data Protection Act apply to me? Okay, I'm a man. But if we want to go down the person route, okay, quite clearly, I can break that act for the greater good. Okay, I've recorded her saying things that she quite clearly shouldn't have said. Okay, we now have, and we're now in the knowledge of, that there's a fraud being committed, securities theft. Okay, my worst suspicions, my worst fears were confirmed. That's why I recorded it. Okay, so I can, as a person, I can break that act for the greater good. As a man, I'm not bound by it. Okay, so whichever way, she can't tell me what I can and can't do.